Fariba Sarouche.
Here.
Okay. Let's see if there is any public comment. We have one member of the public. If you'd like to speak, you can raise your hand. I don't see anything, so let's go ahead and get started. I think we were planning to pick up where we left off with this document. And I believe we were here, financial arrangements with other paraprofessionals.
Right.
So that sounds good, but do we want to follow up on the comments from the full working group on our presentation, or
Okay.
we can do that separately if you want?
No, let's go ahead and start with that. That makes sense, Amos. I did forward the two of you the additional information I got on the MCLE requirements for specialists.
Yeah, and one comment which I think I'm in favor of that we got during the full working group was make half of the CLE self-study, because that was that would be consistent with other MCLE. So I don't feel strongly, but that seems fine to me.
Okay.
Fine. That's fine. It makes sense. So your email this afternoon just updates our information. 42 units needed, 19 of which could be general, and the rest, right? Well, 6 of them of those subspecialties, but the rest have to be in their specialization, correct?
Right.
Okay.
So
that sounds fine.
Just answering the question that that was raised at the meeting, and we couldn't find the information on the website. So it's not, so really it's 36 hours. It's a 42-hour requirement, not 36.
Mm-hmm, mm-hmm.
6 is the 6 of the hours can, let me just pull this up so we can take a look at it. See where I am. I'm trying to find that email. Here we go. If you guys can see this. So 36 hours of continuing legal education in the specialty area, plus the 6 hours of MCLE in the subfield areas up here: legal ethics, competence, elimination of bias. So there was just a question about that. So it would presumably, if we wanted to parallel this, then the continuing education requirements for the paraprofessional would be, virtually all of them would be in their area of certification.
So I think that's what we did. I think so what we did was everything other than those 6 hours of specified credits, we said everything had to be in their specialty area. So I think the question is, do we stick with 36 hours or do we bump it up to 42 if we want to track this? The truth is I was fine with 36, but I don't feel strongly about needing to track this and do 42, but I don't feel strongly. What do you think, Fariba?
I just think it's kind of easier to explain why we chose 42 hours, versus we just said 36 because we were mistaken. So also it's specialty, they're specialists. And I thought were we recommending that we add 1 unit to the subfields of trauma-informed training? Were we going to recommend that, or just for family law?
I think the question is, we are going to recommend it, but the question is it just for family law? And I think Judge Yu thought it should be across the board. And again, I think we're just in the position of how are we going to justify it? It's a new, different requirement than what attorneys have. I like it. I think it's best practices. I think it's a critical area. So I do like it. But again, we will probably have to justify it.
So let me jump in for just a second. Leah and I did a presentation to the State Bar Board of Trustees earlier. What was that, Leah, 2 hours ago or something?
Yeah.
Recently, in the recent past, so I can still remember it. And I'm going to share this, when we have our next full board meeting, but I also want to share it as we go through these subcommittee meetings. There was definitely a reaction that we are making this too difficult, that there is too many hours, too many requirements, and that we need to keep in mind that we're not comparing people to what they can get with an attorney, but what they're getting currently, which is nothing, or potentially deleterious information from people who are potentially fraudsters, depending on the circumstances. So there was, my sense was some concern that we are making this too difficult overall for the barrier of entry. Was that your impression as well, Leah?
Yes.
And so I want to throw that out there because I think that's important to consider. And as I was going through, Leah put together these fantastic slides for the presentation today. And as I was going through it again with kind of a new set of eyeballs over the last few days, I will say that I kind of had that impression as well. I mean, we do have to keep in mind the goal of getting people, of course, we're all protecting the public, getting people out there to help. So that's not in particular to this, one item, but as we add item to item to item, we wind up with a lot. So that's my, peanut gallery commentary.
Very, very helpful. And this is one, and we heard it from the full working group too. There were at least some people who were concerned that this is too high hours. I mean, I think it should be at least now I forget, was it 24, 25? The 25 hours is where we started for attorneys, and paralleling that, we went to 36 because we thought that made sense for specialists. And now we're thinking about 42. So we can put a pin in this, and for everybody, we can think about this. We don't have to finalize it right now, but I do think it makes, this is, of course, CLE is one of the few proactive educational competency things that it's not hard to do. It's not actually a lot of hours because it's over 3 years. And hopefully we'll create some trainings that are really specialized and helpful. But yeah, I think we absolutely should consider that. And so I think the range that we really are in are the 25, 36, or 42. And I think, let's get everybody's opinion. And I don't feel that strongly about it. I mean, there should be a CLE requirement.
Right.
I think this is a learning process for us too, as we go through it.
Exactly.
And as you said, looking at it from a fresh perspective, having received input that this looks too hard. And we certainly can look at it with that lens on and go, 36, 42, 25.
Right, which also forces us to think about in all the things that in our, in your dream world, if you could wave your wand and have all of these things, fantastic. We probably can't. So that forces the more difficult analysis of what of these things are more important.
And for me, it's important to kind of achieve a balance with best practice, not making it too difficult. And frankly, I think they are not attorneys. So we have to sort of make it so that it reflects that these people are not attorneys. So
although we may have quite a few people who did graduate law school, which makes it more complicated.
Yeah, the Arizona paraprofessionals are 15 hours per year. So that would be 36. That would be 45 for if we're doing it on a 3-year scale. So I think all 3 of these options are in the ballpark, and yeah, let's give that some serious consideration of barrier to entry.
Okay.
And just going back to, sorry, Leah, I didn't mean to interrupt you, but just we were talking about having a subfield for trauma-informed training. And I think that we were sort of, well, I guess the number one question should be added now that we have the new input. And I think we should, just because it's best practice. Number 2 is whether it should be across specialties or just family. I think it should be across specialties because it's really about helping people who've experienced trauma in their lifetime, how service delivery should be different to be able to effectively reach them, assist them, get the information you need to help them. So I would recommend that we have it as a subfield for all specialties.
And that wouldn't be additional hours. That would be counted in the hours we're talking about.
In the subfields, I would suggest that it be in the subfields. You know, the subfields, forest ethics, whatever we pick the subfields to be.
So you might want to have 7 hours in subfields instead of 6.
Exactly.
Yeah.
Tomorrow at the licensing subcommittee meeting, we are going to hear from a professor at UCLA Law School who's teaching the course on trauma-informed representation. So that'll be really interesting to hear what I think that's a full quarter course. Yeah. So
Great. Yeah.
Was there anything else from the full working group? I'm just looking at my notes that we should incorporate or discuss.
I don't think they were surprisingly quiet on the whole malpractice issue.
Yeah, even though we invited commentary on it, didn't get it. But granted, it's not like we had previewed it for them, like, please come ready to answer this question. But yeah, there wasn't really commentary on it, other than, again, that might fall into the bucket of, are we making this too difficult for people? Especially if we're imposing requirements that we're not imposing on attorneys.
And I'm just repeating myself, saying that it's just for their own protection. So if a paraprofessional has enough to protect, they have a house, they have assets, and they just don't want to risk exposing their
Well,
assets.
but why don't we do it for attorneys? I mean, it would be for the attorney's own protection too.
Oh, no, I'm not saying require it. I'm saying leave it up to them. If they have assets to protect, they can. If they don't want to, they don't want to. That's all, that's my position. And Linda talked about that work group recently that they formed to review the malpractice insurance issue and whether to require for attorneys or not. Didn't she say that they sort of ended the work group without any change to the current policy?
Yeah, I thought she didn't she give you guys a bit more of a detailed overview of that effort at one of the
And at the end, they ended up not recommending.
Yeah, but it's an extremely politically charged topic. I don't think the decision not to recommend was purely on policy.
Oh, okay.
Yeah.
Right. Yeah, no, I think that's right. One of the other notes that I made was about the informed consent requirement. And Greg, this is one I think you were particularly interested in us getting feedback, because it might be duplicative, or we might be doing things twice because of the written agreement, disclosures, and the informed consent. I thought that was a very interesting discussion, but again, I think there was a split of whether that is an oral thing or a written thing. So I don't know that we got a full answer, but I do think, probably what makes sense for the draft language we put together that we previewed for the full working group is to move forward with the analysis of where does that go and what does it look like. That wasn't final language, but I think we have the general ideas. And I think as next steps, it probably fits in with the review of the rules of professional conduct, or if we're deciding some of them should go in rules of court, proposed rules of court. So
I may have missed it, but were there people for advocating for it to be verbal rather than written?
at least one person, yeah.
Was it rather than? I thought it was in addition to.
Yeah.
So that's how I like it. I like it as an oral, but best practices is to write it down and have written confirmation of it, or something like that. Yeah, but I think at least one person said, I think in their mind, they read the written agreement and disclosures as the written part and the informed consent as the oral part. And again, I think that's just how they read it. I don't know that that's necessarily their recommendation.
We tend to, in our rules in California, we tend to require writing more often than other jurisdictions for informed consent, partly because it helps with enforcement and compliance with the rules. There are some exceptions to that where verbal disclosure is permitted in certain circumstances under certain rules. But for the most part, we tend to require a writing of some kind.
So we can do, oh, sorry, go ahead.
No, I was just gonna say that also, back to Fariba's point of, protecting the practitioner. Honestly, I feel like that also protects the practitioner to be able to say, this is what I actually provided, as opposed to getting into some debate about who said what.
And in the language in the contract could be, the paraprofessional informed me of the following orally, for example, and just have your list of disclosures right there, and the client signs it.
Yeah, so my sense is we're ready to move forward. I think we should go back to where we were and continue that discussion, but I don't know what we think in terms of next steps of finalizing proposals on those recommendations, and particularly where they should go, and playing with the language in a way that makes it a little bit more appropriate for final rules or rules of court, et cetera.
Well, I would suggest that we go through the list that we have right now, taking up financial arrangements between paraprofessionals. And then I think we should, because I don't think we've gone through in detail yet, Amos, the suggested rule that you patterned on Washington's rules. I've had a chance to go through Washington's rules of professional conduct for the triple LTs as well. And there's a lot of cross-referencing between that set of rules, and in some ways we might want to do it differently. It gets back to that basic question of what is the consequence for a violation of the rule? Is it discipline? Then the rule of thumb is then it belongs in the rules of professional conduct. But I think we can go through. I have some specific ideas about particular provisions that really replicate what we already have in the lawyer rules. That may be more appropriate in the rules of professional conduct, and then others that I have some questions too, because some of the rule writing that they did in Washington they use a lot of vague terms, and I think it's it gets back to this idea we want to write our rules clearly so that we encourage compliance and provide a definite roadmap for these paraprofessionals to follow.
That sounds great.
Okay.
Sounds good to me too. And I definitely, one of the areas I want to cover is, does the paraprofessional sub in and then they have to sub out? Those rules apply to them too, as they do to attorneys. Can the attorney for the other, if there's an attorney on the other side, talk directly to the client when they have a paraprofessional? So again, that really makes it less risky for the attorney on the other side. We need to also watch out for that they know exactly what they can and cannot do.
Mm-hmm. Mm-hmm.
The final note I have to raise, I'd be very interested to hear what you guys thought of the discussion about fee limitations. Sorry that got missed at front and put on the end, but it's an important issue and it was an interesting discussion. I don't know what direction we take from it.
What was
It's a
the
big topic.
consensus that day about having a fee schedule and fee limits?
I would say there strongly was no consensus. I think there were several comments on both sides. Some pretty strong, saying let the market decide, it'll sort of regulate itself. And some saying this is, if the real purpose is a low cost alternative to attorneys, there are easy, obvious ways that you can regulate that. So, I don't know.
Easy and obvious? I don't know about that. I don't think there's ways, but I think it's a science. I mean, it's not even a science. How do you set an artificial level?
It is difficult to set what those fees should be, but it's easy to just create a schedule and a max. So I just don't know. I'd be interested to hear what you guys thought from any takeaways from that discussion.
I'll share what I thought, and then I want Brady at some point you to jump in with the legal analysis you've been doing of our ability to actually set fee limitations. I did not think there was consensus, but I do think there will be universal consensus around reporting what the fees are that are being charged. So I think that is a point of agreement and something we want to make sure to implement, I think, because that's going to be really important as an initial threshold step. So I thought there was consensus around that. I think there's a recognition that there are fee limitations in certain areas already. Workers' comp came up, right? Sort of the good and the bad of it, that the fees that have been set or prescribed are reasonable, but perhaps they're so reasonable that attorneys take tons and tons of cases in order to make a living. And that's the challenge. So I don't know. I think if you want to move forward with it, we would need to bring some kind of a proposal to the working group that would be based on something. We've gotten from the Judicial Council information on the current methodology for setting the dependency council rates, which Linda and I mentioned at one meeting. I've got some feelers out with the incubator programs to see what those attorneys are charging. Obviously, we have the statutory caps that do exist for certain proceedings. So I think we need to bring something forward concrete for people to react to, if that's what you want to do. I will say, just channeling Justice Petru's comments, that I'm curious how the board would react to that, given their desire to like see this as a viable program. I don't know.
The other comment that I thought was very, very good, and sorry, I forgot who said it, but to really try to work this into the informed consent piece. So more about disclosures, and we'd have to work on the draft language, but if people are specifically told what an attorney would be available for, and this is my price, that it's not necessarily a fee cap, but it is sort of, an education point. So we'd have, there might be a way to do it in disclosures where if we could have effective disclosures of what the availability of and cost of an attorney would be.
Could we, for example, just set it after the modest means panel rates for bar associations? I know in Santa Clara, I don't know if that's state set or is it per county, right? It's per county. So in our county.
And it's probably not available everywhere.
Yeah,
It's $100.
they don't do it. That
Right.
Linda shared with us, right? They just say affordable or something.
Right. $100 an hour still here in Santa Clara County, $41 consultation fee.
And the truth is, my concern and why I am an advocate of doing something here is, my concern isn't if in several of these practice areas, and we have to figure out what paraprofessionals will be doing, but if a lot of it is going to be filling out judicial council forms and giving some limited advice and helping prepare for hearings, if it's $300 or $500 an hour, that's going to be a problem to me. And if it can be justified to say, well, somebody at Skadden and Arps in San Francisco charges $1,000 an hour, and this is less than that, I don't think that's any kind of meaningful protection or regulation. If it's something, and so I think there's got to be some way. I think informed consent might be a solution to this if we can build in a meaningful way to do that.
I think that a lot of people can protect themselves by that and will shop around in the age of internet, going to Google. But I think, Judge, you made a really good point that people, monolingual, non-English speaking people who go to a paraprofessional that speaks their language or has someone in their office that speaks their language, or maybe from the same country as they are, even though they're both English speaking, may want to stay with that person and may not check rates. And then if they're monolingual, then they may not even know. So yeah, informed consent would be helpful to that person, but I'm just wondering if they would even read it. I mean, we get a lot of people here that just don't read what they're signing, even if they speak English. A lot of it is trust, a lot of it is just not being functional. So it worries me.
Sorry to digress so much. I think we can go back to what the agenda was for today, but I think this is a tough one. So I think we need to still sort of brainstorm about it. I would be most in favor of having some bright line rules that's easy to enforce, but I think some kind of informed consent might be the best alternative to that.
Brady, did you want to just share, if we were going to go down the path, which entity is the safest entity to set these fee caps?
Sure. So either the Supreme Court or the legislature itself. A question arose a week or two ago when we were discussing this, whether there would be any antitrust issues to setting price ceilings. As a matter of the merits of an antitrust claim, at first you might think, well, that's pro-consumer, but you could imagine a situation where us as or a board populated by attorneys setting a artificially low price ceiling could be anti-competitive in that it would limit basically the population of paraprofessionals out there if we didn't craft the policy in a way that they could actually make money and compete. But before you even get to the merits of whether there would be an antitrust violation of any fee cap, very likely a fee cap that we developed, depending on how we did it, would be immune from antitrust enforcement, or there would be no violation. And that's under the Parker immunity principle, which is basically that if it's state action, a state policy creating the anti-competitive effect, that's immune from antitrust enforcement. There's a test from a Supreme Court case called Mid-Cal. Let me step back a minute. So that Parker immunity would apply if it were the Supreme Court or the legislature, the state, in other words, clearly saying, here's what the price cap is, here's what the policy is. If either the statute or the court rule delegated to some other body, whether the Board of Trustees of the State Bar or some new paraprofessional board, then there would be a question as to whether that body, presumably because it would be populated by market participants, whether paraprofessionals or attorneys in practice, there would be a question of whether that board is entitled to Parker immunity. And under the Mid-Cal test, there's two factors. Number one, the board's action in setting a price cap must reflect a clearly articulated and affirmatively expressed state policy from the legislature or the courts. There has to be close instruction. The policy has to be set forth. And then whatever the board with the delegated authority to set these price caps did must be, quote, actively supervised by the state, by either the court or the legislature. So if we did want to go down this path, the cleanest way to avoid antitrust enforcement would be for it to be, set at the very highest level by the legislature or the court. If they wanted to go the road of, delegating some flexibility, then further analysis would be required to make sure that, we didn't run afoul of antitrust issues.
Yeah, very interesting. And I assume like court or like superior court rules, local superior court rules about how much attorneys make on their, criminal panel. I assume that does not have antitrust issues because it's sort of voluntary whether you take those cases and you sort of are opting into that system, or is it because it's set by the court?
It's the court setting it. So it's, it's again, the state making that decision rather than market participants.
Yeah, but it's also 100% voluntary if you choose to take a panel case, right? Yeah. So something to keep in mind if you want to pursue that versus the informed consent route. So should I put up the policy document now?
Yes. Sorry about the digression.
All right. Let me hold on. I've got to close out.
I think we were, let me pull up my version too. We were just starting to talk about referral fees,
Right.
which is another topic and that people have strong opinions on.
Yes,
So I don't know if you have any questions about the background. The general prohibition that on runners and cappers, which I know Steve Fleshman has alluded to, is in the Business Profession Code section 6152. One carve out from that general prohibition on having runners and cappers is that there's nothing to prevent the court through its rules of professional conduct to permit those types of arrangements. And in fact, we do permit pure referral fees in California. We're in a minority of jurisdictions that do so. I provided you, at least from one case, the rationale for that, to encourage attorneys who are taking on a matter that's beyond the scope of their competency to make a referral to a professional attorney that can handle that case. It creates an incentive for that, and the client benefits. Of course, the reason most states prohibit this kind of referral fee is because they're concerned about the arrangement compromising the independent professional judgment of the lawyer. And so the way in which most states handle, and that they refer to as really fee sharing, right? So you're following rule 1.5.1. And the difference in a lot of other jurisdictions is that the attorneys have to be compensated for the amount of work that they are doing on the matter or taking responsibility for the matter. We do not require that. We did for a period of time in the 70s, and then we repealed that rule. And so that is basically the background on fee splitting among lawyers in different firms. So the question for the subgroup is whether or not we want to permit and we can start by just talking about paraprofessionals, whether or not we want to allow pure referral fees among paraprofessionals. So if you have a paraprofessional who is licensed in family law and their client brings up a matter that may, and they may benefit from the services of another paraprofessional licensed in collateral criminal, would they be permitted to refer that matter to that other paraprofessional and receive a fee from that paraprofessional? Now, one other thing before we get into this, under Rule 5.4, there is the possibility of having reciprocal referral arrangements between lawyers. Have that, they are able to do that with non-lawyers as well, and as long as it meets the requirements under the rule. Okay, so it can't conflict with any other rule, so you have to do the conflict of interest analysis that you normally would do under Rule 1.7 or 1.9 for former clients. And then you would also the agreement cannot be exclusive. So you can't just say, I have an exclusive arrangement with this chiropractor to refer me patients and vice versa. It has to be. So the way most attorneys avoid any ethical conflict is when they are providing referrals to another professional or receiving them, they hopefully are asking the person who's referring them to include them among other lawyers that they're referring. So it doesn't give the impression that it's an exclusive relationship. And the client, of course, needs to be informed of the nature and existence of the arrangement.
So this is like accountants, for example.
Yes.
Things like that. Okay.
Mm-hmm. Right.
Greg,
go ahead.
The first rationale, right? So that you're encouraging folks to kind of be forthcoming about areas that they're less capable of providing representation in. Mm-hmm. Is that not a relevant issue in this paradigm because there's a practice specific certification required? Or is it are we thinking like within a family law certification, you may be really good at, I don't know, divorce, but you're not that good at something else that you're certified and authorized to do. And so then we want to create an incentive for you to not do that work. I'm just wondering if it's a little bit different because it's not a general license the way the
I think you're right, Leah. That the rationale for, that underpins the rule for lawyers being because lawyers are, as Rebecca Sandiford likes to say, omnicompetent once they're licensed. So they can potentially practice in any area. If they make themselves competent in that area, they can do so. Mm-hmm. That rationale sort of falls apart here because we are licensing these paraprofessionals in certain very limited areas of practice. So I guess you could conceive, like the example you were providing of a family law paraprofessional that was specialized even within that area in some form of practice, but it seems like that would be a rare instance.
Actually, we see that a lot in family law with attorneys right now. So there are family law attorneys that don't touch DV. and they actually bring in or farm that piece out to, and their attorneys just do DV, they don't touch property. And they farm that out, you know, so I think the scenario mentioned is actually quite possible. Although we are, in this particular program, we are going to train all paraprofessionals within their specialties on all those issues. But again, a paraprofessional may choose not to handle a domestic violence restraining order case just because, you know, they don't want to for whatever reason. So in that sense, they would be referring it to another family law paraprofessional.
And there's nothing to prevent them from having a reciprocal referral relationship with that paraprofessional as well as other professionals. So the question is whether or not they're going to receive part of the fee. And if there is a referral fee, of course, you have to comply with Rule 1.5.1. So you must obtain informed written consent from the client. Like the entire fee cannot increase by virtue of the referral. So you can't tack it on to the fee that you would normally get if it's within the scope of representation already. So.
And Greg, do the current rules here then, if I'm reading it correctly, would a paraprofessional qualify as a non-lawyer professional under 7.2B4? Or no, like for a reciprocal referral arrangement on the attorney side, would they be allowed to enter into such an agreement with a paraprofessional?
No, lawyers would not under the current rules. So that's why we have to put aside for a second whether or not these arrangements can be, whether you can have pure referral fees between paraprofessionals and lawyers. Because that would require a change to the lawyer rules. And I think, as Steve Fleshman pointed out, that is one of the areas of study for the Closing the Justice Gap group. I think that there's some overlap between that group's charter and this group's charter when we start talking about whether or not lawyers and paraprofessionals can combine together in firms, which we're going to talk about later. But this is really about referral fees among paraprofessionals who are not in the same firm, and whether we want to pattern that on the rule that we have that allows for pure referral fees between lawyers who are not practicing in the same firm.
Is there also a question of whether we want to create a prohibition similar to Business and Professions Code 6152? Because I think technically that only applies to attorneys. So if we want to prohibit runners and cappers, I think we would have to create that rule. Well,
yes, we would. And we do have the general prohibition under 7.2. Let's see, that we could adopt here and just not have a carve out.
Not have 1 through 4.
Well, you could have, but you could say can't pay anything of value. So anything of value for a client referral, except for, I think you need to have some of those exceptions. Obviously, they need to be permitted to pay reasonable advertising costs. There's been some talk about having certified paraprofessional referral services. So that would be an exception under this version of 7.2. And the payment for purchase of a law practice. And then we'd have to decide whether you want to allow reciprocal referral agreements between the paraprofessionals and non-paraprofessional, non-lawyers. And then 5 is that's another exception under 7.2, which is lawyers are permitted to give a gift or gratuity to someone who made a recommendation, so long as it's not pursuant to any promise or agreement that they would be receiving it, and it's not made or encouraged in the future. So there can't be a pattern of this. It has to be a one-off.
So can I ask, this is a little complicated and very controversial, and I'm still developing my thoughts, but do you mind if I sort of attack this from a different perspective and ask some questions? Because I kind of want to go back to first principles. I honestly think the question about referral fees is much more important and maybe much more difficult, between a paraprofessional and an attorney, And so that's sort of where my mind keeps going. But from first principles, I think I would like to be able to set up this program where paraprofessionals can, and maybe are encouraged to, set up firms together and refer cases to each other. I think all that is a good thing. And referral fees, I don't think they're such a negative thing. I think it's part of business. So I would like to see us be somewhat open about this. But again, I think it all goes into the runners and cappers and the referral fees between attorneys and professionals. That's the harder question. So I don't know, maybe is one option to just track attorney rule. I mean, I don't know that we need to be more liberal, but is one option just sort of to track the attorney rules, at least with respect to paraprofessionals among each other, and then they could share fees. I think that's the different rule, but assuming 1.5.1 will be something similar for paraprofessionals, so they can work together in firms, they can refer and do referral fees under the same restrictions. But I think that still leaves open the questions of whether runners and cappers are prohibited specifically. And what about working in a law firm with attorneys or referring cases to attorneys, which I think are the difficult questions here.
And I'm trying to think what's the negative for following the same rules as imposed on attorneys, and specifically from the standpoint of the new comments and input we've gotten with regards to not making it too difficult for paraprofessionals.
Well, I imagine you're probably going to hear the counter argument from Steve Fleshman, so I think we need to try to channel him in some way, because he seemed to be very opposed to allowing for referral fees among paraprofessionals. I'm not sure if he has really developed that argument for us yet. I think the concern is that he believes that it will just be, he's concerned about runners and cappers, and that it'll be difficult to police, if somebody wants to set up a referral mill. I think the way you get around that is through adopting the regulatory structure we have right now for attorneys. We do have a whole set of rules for certified lawyer referral services that we could adopt for paraprofessionals as well, so that there are regulated devices that allow paraprofessionals to receive these referrals. And we're still, have the rules in place that protect their independent professional judgment. The bigger question, and looking at some of the other states in terms of combining into firms with other lawyers, it seems like every other state that has adopted a program is permitting that. And it may be helpful, I think, perhaps to put together a matrix that shows what Utah is doing, what Washington's doing, and Arizona around these rules.
Did you meant to say combining in firms with lawyers versus with, okay.
What did I say? I'm sorry.
No, that's what you said. I just wanted to make sure.
Oh, yeah.
Can you go back though, Greg, and just give a concrete example of how our current regulatory structure does prohibit or protect against runners and cappers? Because we do allow for referral fees and we allow for fee splitting among lawyers. So what is it exactly that protects against this concern that Steve Fleischman has in the world of lawyers right now? Okay,
so in terms of how we police runners and cappers, because a lawyer can be a runner and capper for another lawyer, right? So the way we protect against that is we require them to comply with Rule 1.5.1. So you need to enter into a written agreement with the other person on the particular matter, not just a global agreement, I'm going to send you referrals. It has to be this specific matter, we're entering into agreement to split fees. And there's not a requirement that the lawyer who is referring the case do any work on the case or take professional responsibility for the case. They do have a professional responsibility on the referral. They need to exercise they have a duty of competence to make sure that the person that they're referring the client to can actually handle the matter. And if they don't, if for some reason the person they're referring to is unable to competently provide legal services, then they can be disciplined. The referring attorney can be disciplined. So first of all, they need to enter into a written agreement with the other lawyer. They also have to obtain the informed written consent from the client, and the entire fee that's being charged to the client cannot increase by virtue of the agreement between the lawyers. So that is how that works. So essentially, the lawyer who's receiving the referral is taking what they normally would charge the client, taking up a part of that fee and giving it to the referring client, to the referring lawyer.
So
That's just among the lawyers. Now, the way we police runners and cappers when we are dealing with non-lawyers making referrals is also this set of rules. In terms of the person who's making the referral and receiving a referral fee, who's a non-lawyer, they are open to criminal prosecution under the Business and Professions Code, as well as the attorney is. The way we police the attorney from a regulatory perspective is through these rules, Rule 7.2. So they're receiving consideration in exchange for a referral, and that violates that rule. And so we have had cases, and I'll send you the Rudder Guide examples, illustrations of how these rules are enforced.
Okay.
So, and I'm getting up to speed, so this is somewhat new to me. And so I think my take on this might be helpful as well, because referral fees are alive and well with attorneys. Just to be clear, it is a very common practice, and especially among smaller firms or solo practitioners, referral fees, getting or giving is a big part of how practice of law happens. But these rules do regulate it. And so, and I think there is a lot of controversy of whether this is a good thing or bad thing. But I see it as, I think Greg set it up perfectly, three different statutes or rules. One is the blanket ban on runners and cappers in the Business and Professions Code, which just says attorneys cannot use non-attorneys to solicit business. That's a runner and capper. It's just prohibited. And then the Rule 7.2 and the 1.5.1, which are basically exceptions of allowing it. One way for attorneys and one way for non-attorneys. One thing that what's that?
And 5.4a.
And 5.4,
which is it forbids lawyers from sharing legal fees directly or indirectly with non-lawyers or organizations, subject to the
right
exceptions, which includes the gift and gratuity, which a lot of lawyers use too.
Absolutely. And this is where the other committee is going to be doing a lot of work, right? The 5.4 area, which is really important about it, even if you can have firms together. Yeah. So it's complicated. I mean, one of my reactions is, why are we making this so complicated? I mean, we're creating this new licensed professional, and I think our knee-jerk reaction, and maybe the same reaction after thoughtful consideration, is a whole parallel set of rules because we're comfortable with them. They've been vetted. They're approved by the Supreme Court. But just so you know, one reaction is this is going to be a long, complicated thing for licensed professionals to learn and understand. And a lot of attorneys don't understand these rules. And there's ethics professionals who know this stuff. I kind of feel like we're making it too complicated. But I also understand that this is, if we're treating it like a professional who is practicing law, it makes sense to do this. But I just want to have that out there that, there might be a way to really, really simplify this if there's any way we can get comfortable that what we're really doing is we're allowing people to do much more limited things, with helping with, judicial counsel forms, some limited advice about which forms and which boxes and how to fill it out, and maybe some expanded to go to court or to do some things. And if it's viewed in that light, I don't know that we need to create this whole system. So just a thought out there. But for this purpose, I think I am in favor of just paralleling what attorneys have, because I think even though it's complicated, it's permissive of allowing referral fees, and referral fees could be an important part of making this a viable profession.
I would actually want to understand this from actual practical examples. And I may be looking at this totally wrong, but for example, if somebody becomes a paraprofessional and they send out letters to, let's say they, I don't know, even know this is possible, but buy the list from the local bar association. I think they do sell their membership list, and sends out a letter in general. And I get those letters from attorneys sometimes, even though I work here, I still get it because I'm a member of the local bar association. And they introduce themselves, their specialty, and all that. So if a paraprofessional did that, and the attorney actually called them and said, "Oh, I'm willing to refer the cases to you. This is my referral fee." How does that happen? I mean, I'm sorry to be so ignorant about this, but just trying to see what evil we're trying to, other than runners and cappers, I get that piece. But what evil are we trying to eliminate here or prevent?
What are we trying to prevent by allowing pure referral fees among lawyers?
Right. I mean, why, if a paraprofessional is on the list of, so because a family law attorney, right now they do that. If they get a client and the client says, "I can't afford your services," and they refer out, they sometimes send them to us. Well, of course, we're public, but they do refer out to paralegals because the person can't afford representation. I don't know if they're sharing fees. I don't know anything about that. But what I'm saying is, in that situation, is that illegal to, or is that, sorry, against the rules to have a referral fee?
If I'm not understanding the example, Fariba. So you're
Sure.
saying, is it against the current set of rules for a lawyer to refer a case out to another lawyer and receive a referral fee?
No, to a paralegal, let's say, or a legal
LTA.
document examiner.
To a paralegal, or no, because they're not referring the matter to another professional that's going to provide them legal services.
Similar to what their representation.
Or paralegal is not actually practicing law.
Okay.
Okay, so the rule is really intended, the rules that forbid lawyers from receiving from providing consideration in return for a referral from non-lawyers is intended to protect the lawyer-client relationship, so that the lawyer is not beholden to the person that's paying them for the referral fee. Their independent professional judgment is preserved. And if you read that Moran case, I can send that to you too. The Moran case provides this rationale for why we allow pure referral fees among lawyers, but the court does a very good job with the counter arguments allowing pure referral fees there, and all the dangers that that a lot of jurisdictions see with allowing those types of fees and why they prohibit them. Majority of the jurisdictions do prohibit pure referral fees among lawyers who are not in the same firms. So the concern is that if you have those kind of relationships, then you're going to start referring your cases to whichever lawyer is going to pay you the most for the referral fee, and not referring these clients to people that you believe are competent and able to handle the legal matter. And so you need to you have duties, fiduciary duties to your client if you're going to refer them out to another lawyer, and you don't want them breaching those duties to the client by just handing off your client to the highest bidder, essentially.
So the best interest of the client standard.
Yeah.
Okay.
Well, Greg, what do you recommend? Like, are these bifurcatable, if that's a word, issues? Like, number one, would we want to recommend that 6151A be modified to include paraprofessionals?
So that that you can't be a runner and capper for a paraprofessional.
Yes.
I imagine that the legislature may want to do that. I'm not in a position really to recommend what the working group do here, as you probably know.
Sorry.
But what I will say is, I thought your point, Leah, was a really good one, because I think that the rationale underlying the pure referral fee rule here in California is somewhat shakier in this area, because you are not necessarily dealing with a licensed profession who is otherwise omnicompetent and could potentially take on that matter themselves, rather than referring it out to somebody who's currently competent to handle it. So I can see that there are some instances in which, as Fariba said, that may be true, but it's just not as strong a rationale as it would be for lawyers.
But even more of a rationale, I think, to encourage paraprofessionals to refer to lawyers. That's where it's because you want them to not be tempted to practice outside of their authorized scope.
Right.
And
Competency, right.
yeah, so it's interesting there.
Yeah.
You can see why you would want that referral fee
Mhm.
arrangement, but all of the inherent risks, right? They're-
Right. And if you don't allow for that kind of referral fee in that instance, then it's not a level playing field in terms of the paraprofessionals who are in a firm with another lawyer and able to have those kind of back and forth referrals within the firm, as opposed to the paraprofessional who's a solo practitioner.
Okay, so on
Whether
this,
or not that benefits the client. So in terms of what I recommend, I mean, I really, it's a tough question. This is one of the reasons I wanted to make sure this group started wrestling with it, because as you can see, it affects at least 3 rules and 1 provision in the State Bar Act. And it's taken years to develop this regulatory framework here in California. And as you can see, it went back and forth a bit in the 70s. And so they're not easy questions, but they are something that we need to address in one way or another.
so
I will say that the one thing I will say also is I don't necessarily agree that in terms of making a recommendation vis-a-vis the relationship between paraprofessionals and attorneys is beyond the scope of this group's charter. I think there's some overlap with closing the justice gap, but I think the court would benefit from recommendations from both sets of groups and both groups. And if the groups eventually need to coordinate the recommendations, then so be it. But I think the more thinking we have on this topic, the better.
On that point, I think it also might be a possibility, especially if we're first in the timing sequence, which I think is how it's going to play out, is that we recommend something that parallels current rules for attorneys. And then if the other working group says, well, actually, those should be expanded or changed, then that could be both for attorneys and paraprofessionals. But I don't know that we can create this regulation without addressing this is a big issue.
Right.
So I'm highlighting things that I'm just thinking. So we would, and just jump in and correct me, but I think we would want to keep the general ban 7.2b. This is kind of in line with what you're saying, Amos. Keep the exception for advertising. Keep the exception for the lawyer, but this would be like the paraprofessional referral service, right?
Mm-hmm.
I think we would want to allow for purchase of a paraprofessional practice.
Yeah, I think that's important. We'll talk about that next in terms of firms, but that's
and then we're here in 4 reciprocal referral agreements between paraprofessionals or between a paraprofessional and a non-lawyer.
So to the extent a paraprofessional is created, lawyers will be permitted to have a reciprocal relationship under their rules with that paraprofessional, because they would qualify as a non-lawyer professional.
That's what I was asking you earlier.
Oh, you were?
You
Okay,
said no. Yeah, I thought you said no. So they will be under their rules. Lawyers will be able to.
Yes. I'm sorry if I misunderstood you. Yes. Unless we change it, which I don't see a strong reason to do that, but so they could have reciprocal relationships. Now, that doesn't mean that they're receiving consideration for those referrals.
That's I think the main point,
about that
because
rule.
it could be one-sided, where an attorney could get a referral fee, but a paraprofessional would not be permitted to get a referral fee if it was the other way. So we just have to be mindful of that.
And so this would say non-paraprofessional professional.
Yeah, I was looking, yeah, or it could say between, yeah, we have to do some wordsmithing. We should probably not try to do that now.
Okay.
It's always tricky to try to write rules in a meeting.
So I think what we're saying is we keep 7.2B as it is, but change it to apply to paraprofessionals.
Right.
So is that, so under for reciprocal referral agreements between paraprofessionals, so two paraprofessionals,
Mhm.
or between a paraprofessional and a lawyer. So your second non-paraprofessional.
The way this is between a paraprofessional and a non-paraprofessional. In my rewrite of this, we have.
So a non-paraprofessional could be a lawyer too, as long as they're another paraprofessional? Because you got between paraprofessionals up closer to 4, it says reciprocal referral agreements between paraprofessionals. So you got two paraprofessionals right there. Referral from one to the other.
I
Then the
think
second
if it's written now, it would be like an accountant or like a tax person or something like that.
How about between, from a paraprofessional to a lawyer? Is that the same thing as, it's just two ways between paraprofessional?
You could say referral agreements between paraprofessionals, or between a lawyer and a paraprofessional, or between a paraprofessional and a non-lawyer, non-paraprofessional. So this is why it's we need to.
So
I know that some of the other states have already grappled with this because it's a little tricky to how exactly to word this, but
it's 3 we're talking about
Yeah.
between paraprofessionals.
non-legal professionals, and it may be, we may have to define a term, the terminology rule, which is rule 1.0.1.
Okay. I think that's what we want right there.
Yeah. This is not the actual rule text, just so you know. I didn't.
Okay, good. This, what's in yellow highlights will not be it either. But I think that's what we're getting at.
Right.
Okay, the agreement is not exclusive. That's going to apply. The client is informed. That's going to apply.
Mhm.
Do we want to allow for the gifts and gratuities?
Yeah, so I think that's just a
I like it.
non-monetary referral fee. It's a bottle of wine or yeah. I think again, it's a common. It's pretty common with lawyers.
Okay.
I'm not sure it's necessarily non-monetary though. I think gratuity can be monetary.
That is true. I've heard of. I haven't experienced that one, but I
Here's a
do
gift
think
card.
it
Here's a 20. Thank you.
Okay.
All right. Fee splitting. The same
Well,
rule.
so the big question here, and this gets to the peer referral fees. This is how we create peer referral fees. Under the ABA model rule and the rules in most jurisdictions, the lawyers in this case that are splitting fees they have to either work on the matter and being compensated for the work that they did on the matter, or take responsibility for the case. We remove that requirement. So if we want to prohibit pure referral fees, then we would essentially engraft on this version of the rule for paraprofessionals the language that we're seeing in the ABA model rule. Or we adopt the rule that we have for lawyers here, which would allow for a pure referral fee. But still with these requirements, the client consents in writing, and that there's a written agreement among the paraprofessionals, and that the total fee charge does not increase.
So sort of have a of counsel or paraprofessional, right? Bring somebody in with a certain expertise.
If they're not in the same firm, if they're, I mean, if they're of counsel and they're really within the firm.
Oh, okay.
Then it's.
So co-counsel I meant maybe, yeah? Okay,
Yeah,
for
yeah.
different firms, right?
Co-counsel, but yeah, I mean, we see this, okay, so a good example of this, I know from my prior life as an employment lawyer, is somebody who really specializes in single plaintiff cases, but in the course of investigating their client's case, they realize, hey, this is a really good class action. I'm not class counsel. I don't handle those kind of things. And they might refer it to a colleague and receive a fee, a pretty sizable fee for that if it proves successful. And so we see that quite often. That referring lawyer doesn't do any work on that case.
I see. Okay. But it would also
Okay,
cover
because-
where the referring counsel would do some work, like stay on. Would that be covered?
I mean, it doesn't prevent them from doing work, but when you say that the client must consent in writing after full disclosure that the division's being made, the identity of the lawyers and firms that are parties to the division, and the
Mhm.
terms of the division. So if the part of the terms of the division is, hey, I'm getting this fee and I'm not responsible for doing any work on it, the client needs to be informed of that.
Okay.
And the concern about runners and cappers is here as well, right? So if there was a requirement that the attorney or paraprofessional do some work on the case, that avoids the runner and capper situation where you're just a referral mill or just being, these people are just setting up rather than doing any substantive work. They're just out there finding referrals and getting compensated through referral fees. So that's the risk, I think.
And very often in those situations, the total fee charge does increase
So,
by virtue of the agreement.
okay. Oh, there's my, yeah. okay.
So what is the idea here, that we would adapt 1.5.1 as it is to apply to paraprofessionals, have a work requirement?
If you do not want pure referral fees, we would put in a work requirement or a responsibility requirement.
I don't think we want to do that. Again, I think I am sensitive to the concern about referrals, but I also want to encourage referrals and not necessarily place barriers for it or for fees. So, I know I'm usually the consumer protection guy, and it would be a consumer protection to do that potentially because of the independence but I just think we should parallel the rules. And I think this is going to be considered by the other working group. So these rules might also be expanded, allowing referral fees even more broadly. I don't know that we should be narrowing.
And as long as it's not seen as making it too difficult for a prospective paraprofessional to enter the field, I think we should parallel the rules. They're important. They make sense.
And I think it makes it easier. So the idea would be this makes more referral fees potentially available to a paraprofessional or in more situations.
Okay. We could probably move more quickly through this. So the next topic, which is forming law firms.
Can I just one note? So the rule 7.2b that we were talking about, my understanding, and I have to go back and check this, but my notes are that is actually an advertising rule. That I don't know why the referral fees are in the advertising rule, but I do think we are going to want to consider other advertising issues with Rule 7. So I don't know if we're not at that stage, happy to do it differently, but I just want to put a pin in. I think we want to consider Rule 7 a little bit more.
Yeah, so there's a bit of overlap. 7.2 is called the solicitation rule. And this is one aspect of the solicitation rule, the other being, you can't make contact with attorneys and offer your services unless it's somebody that you've either represented in the past or somebody you have a prior relationship with. So I think we need to come back to the advertising rules.
Yeah, I made a note of that last time.
And that, by the way, that is squarely in the Closing the Justice Gap group's charter. They're going to take on the attorney advertising rules as well, because there's a strong groundswell to adapt to. Well, one of the problems that we have with the advertising rules is once we, as California, we adopted essentially the framework of the ABA model rules. Within 6 months, the ABA changed those rules. So we finally caught up to them, and then they sped ahead again. So so we need to go back and try to look at those with fresh eyes towards the new model rules that they adopted. In terms of law firms, as I said, going through the rules for the other states that have similar programs up and running, it seems like all of them permit lawyers and whichever version of the paraprofessionals they have, triple LTs in Washington State, or to combine into single firms. And they allow them, the triple LTs in Washington, have an ownership stake as long as it's not a majority stake. And so we need to, I think it might be helpful to, again, to put together this matrix on this and to help the larger working group see what other states are doing, and start considering what recommendations we want to make around this. And I think again, I think the group really needs to deal with it. I don't think it's something that we can just simply allow the Closing the Justice Gap group to address, because they're not specifically looking at standing up this new licensed profession. And this is a critical element to whether or not this program is going to succeed or not.
I totally agree. And again, from a policy perspective, I think we want to encourage law firms, combining for lawyers and paraprofessionals, whether that's existing law firms that hire paraprofessionals or just creation of new firms that have both. I don't see a downside to that.
Mm-hmm.
I guess I'm not understanding. So is one issue, can paraprofessionals themselves come together and create a firm? And we're all saying yes. What did you mean in other states, so long as they don't have majority ownership? Like if it's just four of us, we're four paraprofessionals, we own together 100% of the firm. Are you saying that's not allowed?
Pull up, I was looking at Washington State's, they have a rule 5.9, business structures involving triple LTs and lawyer ownership. So this is notwithstanding the provisions of rule 5.4. Right. So they essentially replaced the word lawyer with triple LTs in the 5.4, and then they adopted a new rule that says, never mind what we said in 5.4, a triple LT may share fees with a lawyer who's in the same firm, form a partnership with a lawyer where activities of the partnership consist of the practice of law, or practice with or in a form of a professional corporation, association, or other business structure authorized to practice law for profit, in which the lawyer owns an interest or serves as a director or officer or occupies a similar position of responsibility. And then I believe they have a restriction. Yes, here. Triple LTs cannot possess a majority ownership interest or exercise controlling managerial authority in the firm.
The firm that's comprised of triple LTs and lawyers.
Right.
But okay, obviously they have a majority interest in a firm that's all triple LTs.
Well, yeah.
Okay,
yeah.
That's what I was having a cognitive disconnect.
No. Just the ones where you're combining lawyers and triple LTs.
So this one, can paraprofessionals create firms made up exclusively of paraprofessionals and support staff? The answer is yes, right?
Yeah. Okay.
I mean, just exclusively of paraprofessionals and their assistants. I don't know why we would say no.
And then we probably want to have the same ethical obligations for managing the firm that lawyers have. And that's really rule 5.1 and 5.3. 5.1 is oversight of subordinate paraprofessionals.
Yeah.
And 5.3 covers oversight of non-paraprofessional staff.
Yeah.
Mhm.
And then 5.2 really sets forth the ethical obligations of subordinate attorneys. And I think we probably would want to adopt a similar rule there as well.
Right. So in a firm that has both paraprofessionals and attorneys as owners, would the paraprofessional supervisory responsibility be restricted to support staff, where the attorney owner's responsibility would be for all of them? Because I mean, the paraprofessional cannot supervise subordinate attorneys, right?
No, but
Or not owners.
they can supervise subordinate paraprofessionals and non-paraprofessionals. So we would want to have rules, and essentially those rules require them to have, if they have managerial control over the firm. So if it's a firm that's all paraprofessionals, that they have structures in place to ensure that the firm is complying with the rules of professional conduct and rules governing the practice of law under their license. And then also having there's for lack, it's not vicarious liability, but essentially what the circumstances under which a managing paraprofessional may be disciplined for failing to take action once they realize that their subordinate has violated the rules, or they authorize them to violate the rules or ratify the conduct when there's an opportunity to, mitigate the harm to clients. So that's essentially what those rules cover. I think it's pretty straightforward in terms of just firms that are paraprofessionals. In terms of firms where you have a mix of lawyers and paraprofessionals, I think we have to decide, do you want to adopt a similar provision that Washington has, which is, paraprofessionals cannot manage lawyers, which is, I think, clear that we should probably have a rule that says that, and whether or not they can have a majority stake in the firm, and that's less clear.
How does that work? Sorry, Amos, go ahead.
Okay, well, and I was going to say, I think the majority share issue is really the independence issue, right? I think, and this is again what's probably going to be talked about in the other group, but the idea is if you have non-lawyers that own and have majority ownership, and even if they're not technically supervisors or managers, they're the ones making the decisions of the firm, which cases to take, whether you need to get out of a case, and are effectively the bosses overseeing lawyers. And that is, at least under our current system, problematic. Whether or not that's going to change is, I think, beyond our committee. That's the 5.4 discussion in the sandbox. So I think if we are going to do this, I do think we should have a similar rule to what Washington did.
This is brand new, right? I mean, we don't have right now, attorneys cannot share ownership of a firm with non-attorneys, right?
Correct. They can't share fees.
They can share fees, but not ownership. And the reason we're considering this is because it's allowed in the other states that have paraprofessional program. Is that why we're considering this as an option?
Yes. I mean, we're considering it as an option because it may be the ideal way for some paraprofessionals to practice, actually.
Yeah. Think about if you had like 3 paraprofessionals doing it might make sense for an attorney, a family law attorney, and then like 2 paraprofessionals, and together they own a firm. And and they decide like what the attorney's going to do, what they're going to do within their scope of practice, but they all have an ownership interest. It probably is the smartest way to create a business.
And they don't have to worry about fee sharing and
they just have a structure. Right?
Interesting.
So
right. We also have a rule that we adopted in 1987, Rule 1, what's now 117, that provide clear ethical standards for lawyers who are seeking to transfer their legal practices. And the reason we had this is really because solo practitioners, it was very difficult for them to sell their firms under existing rules. And so this provides them a framework that they can follow so that they can actually realize that, the goodwill value of their law firms. And so if we're going to allow paraprofessionals to create law firms and practice in law firms, I think we need 117 as well. And those, that framework, essentially you need to, there's notification requirements for clients, and really specific rules around transferring files and when they can be when they can be transferred, and how the fact that fees that are charged clients again can't solely increase by virtue of the sale of the firm. And it's an exception. It's one of those exceptions you see under 5.4, because you also have the situation where you have a paraprofessional who owns a firm who passes away or becomes unable to manage their firm. And so you need to have, in certain circumstances, perhaps their next of kin who's holding the ownership stake for a short period of time and then receiving the value of that firm when it's sold to another paraprofessional. So that 1.17 really provides that roadmap. This is one of those rules where it's not so much the enforcement of the rule, although we do see some enforcement around it. It's one of those rules that provides a roadmap for compliance, for the orderly transfer of a law practice.
So I guess one option is to mirror the rules as they exist for attorneys now, which would mean no ability to have shared ownership paraprofessionals and non-paraprofessionals. So that's one option. Greg, of course, can't be directive, but it does sound like it would be helpful for us to actually take the issue on a bit more affirmatively. And one suggestion is we pull together how other states that have these paraprofessional programs are addressing this particular issue, paraprofessionals, attorneys, ownership structure. And if we were going to go, for example, mirror Washington, or just addressing the concern about independent judgment, you would allow for shared ownership, but the paraprofessional has to have a minority stake.
And one other thing, I emphasized this with the larger group probably at the end of one meeting when everyone was ready to sign off anyway. But and here we are again. But if we are deciding that paraprofessionals will be able to practice in law firms with lawyers, that implicates a lot of revisions to our lawyer set of rules as well. Around 117 on the sale of a law firm, and we need to make some conforming changes to those rules as well, and around the rules of conflict of interest, because now if you're going to be practicing with these paraprofessionals, you are inheriting their conflicts, and in certain circumstances need to create ethical screens, and whether or not we want to authorize that, which I think we would, under similar circumstances. So it goes a bit beyond the charter of the group to amend the rules of professional conduct for lawyers, but I think it's unavoidable, and I think it's probably something that needs to be done.
This is a really useful provision to have to allow this kind of practice, because I could just see if the group decides not to allow paraprofessionals to appear in court, then when we allow paraprofessional attorneys to own a firm together, they could go back and forth in the same case. The attorney could go to court and sort of limited scope, sort of just represent client in that hearing, but then the rest of the work is done by paraprofessionals. So I definitely think that it provides a lot of flexibility, and would just provide another avenue for people to practice this kind of, to have this kind of practice, paraprofessionals. It's a lot more work than if you just didn't allow it.
I agree. I think it's going to be controversial too, for the reasons we mentioned about sharing fees, and legal fees is a tough subject, and there's a lot of discussion and controversy around it. But I think that is the best practice model. I think that is a positive practice model that we should encourage as opposed to prohibit.
Mm-hmm.
So
one other thing I want to just pile on also is considering whether or not, I mean, if we decide that we're going to allow them to practice together in firms, what kind of entity are we talking about? I mean, partnerships are clear, but if we're talking about professional corporations, what statutory changes do we need to consider that?
What rule are you thinking of here?
Well, I think that's statute. That's not a rule in terms of who can combine in a professional corporation. I haven't done a deep dive on that, but I just want to flag that right now that we might want to anticipate that that's going to be a question that we're going to have to.
Is
Okay.
this something that we could consider as a second step? You know, first kind of develop the basic rules and then add this to it. I'm just wondering if it'll prevent a delay from, you know, launching this program, because it seems to me like I'm not worried about the amount of work involved. It just takes time. And if you could just create a simpler model first and just add to it, you know, especially since we're considering a pilot, maybe this could be like the second phase of this project.
I mean, what you could do here is from an ethical standpoint, from a standpoint of the rules of professional conduct, authorize that that paraprofessionals and lawyers can practice together under, you know, these circumstances and in compliance with this set of rules. And that would require somebody to try to figure out, well, what does that look like? Certainly we are permitted to from an ethical standpoint, but how do we limit liability? And at some point, you're going to have the legislature step in and create some forms for these kind of.
And that takes time.
I mean,
Right.
you probably know something I don't here, Greg, but I'm hoping that, you know, under a general LLP that firms often do now, that this would be it would be permissible to have a ownership, you know, a paraprofessional ownership in that. If not, I do think this gets a lot more complicated.
So, Greg, as the next step, this seems like the thorniest issue. However, we do have a clear policy kind of direction. What do you see as the next step in fleshing this one out a bit more, going to Fariba's concern? Because I don't think we expect the two of you to do that. The point was to get your feedback on the policy and then to take it back to the gurus to actually get into the weeds on it. Okay. So I think we're ready to go, but I'm not sure. Because there's a lot more text.
So the one thing that I think we need to do is we still need to address the set of rules that Amos, that you put forward, and try to determine which of those really belong in these rules of professional conduct and which are sort of standalone on the outside, perhaps as a part of the rules of court that stand up the program. And then we've already gone through I've gone through with the Office of Professional Competence, the rules of professional conduct, and did a first pass on revising them to conform them for paraprofessionals. But we did have these large questions, at least with regard to these policy considerations. So now we can go through and make a second pass, and then I think we can provide you a draft set of edited rules. And identify any other issues that we might need to address before you can present that to the full working group. I think it would be helpful for the full working group to, as we discussed, to have Professor Moore
available. Yeah, in April. We just haven't set the date yet, so I haven't been able to reach out to him. I right now need to go Fariba. I'm meeting with Judge Jonathan and right now to work on conservatorship.
Hey,
yeah,
you probably Judge Fariba, okay?
And, but what I would say is I had planned for our next meeting to focus on proactive regulation, but why don't we try to tackle two things? One, to go through the list of Amos rules and figure that out. Mm-hmm. And then also to move into proactive regulation, because again, you do have to come up with a recommendation on that for the February meeting, the rules not till April.
Okay.
So the other thing I would add is I think maybe there's gonna be one more set of Amos rules. which is the advertising rules, the rule 7. So maybe the best thing is between now and the next meeting, I could draft something or put those ideas together for our discussion as well, because I think that should be wrapped into, Greg, what you're working on.
And in terms of your rules, I have some very specific ideas of how we can handle them. And so I can go through it when we're doing the second pass on the rules of professional conduct, try to stitch in the ones I think belong there, and then maybe stand up the other ones as rules.
And where does my set of rules belong? Where does the discussion belong with regards to making a formal appearance? But are they making a formal appearance? Withdrawal. I mean, CCP 284 governs withdrawal of attorneys and notice motions and so on. So does that belong here at all, or is that like a different discussion?
I think that's probably a set of rules of court that define the scope of permissible practice and prohibited acts, which is Amos has already started putting those together, and some of them may be practice area specific. So we might have multiple rules, and then have a general rule that all paraprofessionals need to comply with these requirements, and they're prohibited from doing these things. But
I'm sorry, guys, because I'm late and I need to go. So I think I might, if I leave, I might end this. I might not. We'll see.
This is great.
Okay.
Thank you, everyone.
See you next time. Thank you.